Case 22 CR 240, State of Ohio versus Lyndon Loftis, Loftis. Mr. Pendle is here for the defense, and Mr. Ormsby is here for the prosecutor. Mr. Loftis, first invitation is for you to stop me anytime you get confused. If you have questions, if something doesn't make sense, if you want to talk to your lawyer, doesn't matter to me. Just say so, all right?
Yes, sir.
I'm going to act like you're not here all the time and don't know what's going on. Now, ideally, Mr. Pendle sort of talked you through this, but that's just all good background. Don't apologize if you don't understand. Okay?
Yes, sir.
All right, good. So in this case, the attorneys have proposed what's called a bill of information. There's two ways that formal charges can be started in Ohio. The more common way is what's called the grand jury indictment process. Before a person can be charged with a felony, there has to be a review, a constitutional protection of the grand jury. So you can't be wrongfully accused or presented with an indictment without some showing of probable cause or facts to support it. That's the common way, and it's a constitutional right.
Right.
It's a protection so you don't get wrongfully charged. 95%, 98% of the cases start that way. Equally valid, however, is what's called an information. When a bill of information is presented, it means there's been some agreement to accept an indictment without the grand jury process. That's what's supposed to be going on here. Understand?
Yes, sir.
Yes? When an information is presented, the first thing the court has to do is explain to you that in doing so, you give up a constitutional right.
Yes, sir.
So you understand that process?
Yes, sir.
Okay. Now, the grand jury would be 9 people.
Right.
And 7 out of 9 would have to vote for the charge. If you accept the information, then you're waiving the presentment and waiving the vote. We just go forward without it, right?
Yes, sir.
Okay. For benefit of the record, all these forms were presented to you already, so I'm
Yes, sir.
assuming you've gone over it.
Yes, sir.
But there has to be some inquiry in court. That's why we do it again, and we do it again to give you a better chance of understanding.
Yes, sir.
Okay.
Can you hear all right?
I could just marginally hear.
Okay. I'm not always accused of being soft-spoken, so I'm going to ramp it up. But if it looks like I'm agitated by raising my voice, just understand I'm not trying to be agitated.
Yes, sir.
When some cases come before the court, often it's better to keep the volume down,
I understand.
but in this case, I'm going to amp it up for your benefit.
Thank you.
And then tell me
It's good.
if I become soft-spoken, all right?
Yep.
Okay. Now, the proposed charge in the information is called sexual battery.
Right.
Mr. Pendle should have explained that to you already, correct?
Yes, sir.
Okay. I don't know anything at all about the facts, nor am I supposed to. But in this case, do you understand what that charge means?
Yes, sir.
Okay. As classified in Ohio, it's a third-degree felony. So there's no prison required, but it's up to 5 years in prison as a possible penalty. Understand?
Correct. Yes, sir.
And then there's a possible $10,000 fine, but none of that's mandatory. Understand that?
Yes, sir.
Community supervision is possible, so we call that probation,
Right.
for up to 5 years.
Yes, sir.
If a prison sentence ordered, then there's mandatory post-prison supervision for 5 years.
Yes, sir.
Under parole and probation, you have to follow rules and regulations, restrictions on your freedom. And if you violate post-prison supervision, up to 50% more prison time could be added.
Right. Yes, sir.
So if it was 5 years and violations happen, up to 2.5 more in increments. Understand that?
Okay.
Does this make
Yes,
sense?
sir. I got it.
Okay. Now, when a person's formally charged, they have other rights. First of all, you're always presumed innocent. The state of Ohio, Mr. Ormsby, has to prove guilt, and it takes proof beyond a reasonable doubt. So think of that as a high amount of proof before you can be found guilty. You're allowed to have the case concluded in an open courtroom setting in a timely or speedy manner. If the state calls witnesses against you at any time, a hearing, the trial, Mr. Pendle, on your behalf, has the right to cross-examine or challenge witnesses to ask questions of witnesses against you. If the case goes to trial, you can ask for the jury of 12 or the judge of 1 to make the verdict, and it has to be unanimous. You don't have to call witnesses, you don't have to defend yourself, but you're allowed to. If people would not come to court and you want them here, you can order them by subpoena power to attend. You're allowed to testify if you want. The state cannot force you to testify against yourself. That's the right to remain silent. So do you understand all these rights?
Yes, sir.
Okay. Now, I don't know how far the negotiations went, so I'm going to ask the lawyers what they expect to happen next. When a bill of information is presented, when the lawyers have negotiated a lot, they're usually farther ahead than I know, but I'm not supposed to know anything at this moment in case you want a trial to the judge who shouldn't know the facts,
Okay.
right?
Yes, sir.
So let's hear from the lawyers.
All right.
Mr. Ormsby, you can go first if you would.
Thank you, Your Honor. Your Honor, Deb Quigley is the one who handled this case primarily up till today. She had a meeting at the sheriff's office, so she couldn't be here for this plea hearing. But my understanding was that she had had discussions with Mr. Pendle on the defendant's behalf. And I know earlier today the defendant did execute, as well as his counsel executed, a request to proceed by way of a bill of information, as well as the formal waiver of indictment form. So those were executed and filed. In addition, the defendant was notified about sexually oriented offenses and the penalties such as registration requirements that would be involved with this plea. The bill of information is one count of sexual battery, third-degree felony, as the court already noted. There was, in addition, a plea form that's been executed by all the parties, and that provides that the defendant would enter a guilty plea to one count of sexual battery, that the state would not be bringing any additional charges related to this victim up until today, and then it also makes it clear that both parties would be free to make their recommendations at the time of sentencing, Your Honor.
All right, thank you. Now your turn, Mr. Pendle.
That's accurate, Your Honor. We would note that Mr. Loftis has been advised of his right to proceed with an indictment. He is waiving that right and requesting to proceed with a bill of information today. He's prepared to enter a guilty plea, and I did review the written guilty plea with him, which was signed and filed with the court this afternoon.
Okay, thank you. So, Mr. Loftis, did you understand what the lawyer said?
Yes, sir.
Any surprises?
Nope.
Do you have any questions right now?
No, sir.
With regard to penalties, the easy part was explained to you, maximums, minimums, dollars, and time, right?
Yes, sir.
Okay, there's also sex offender registration requirements. Mr. Pendle often goes through these. Not good enough, I have to also. So generally, sex offender registration means that a person has to notify the chief law enforcement officer in the county where they reside. Now, Ohio calls that the sheriff. And you have to notify them where you live, where you work, go to school if applicable. There's limitations on where you can reside, so generally not within 1,000 feet of a school, a daycare, a similar type facility.
Yes, sir.
You have to notify them at least every 6 months for this level. If you fail to comply, you can be charged with another crime, third-degree felony. You also have to notify them anytime those variables change. So if you take a new job, it doesn't matter when you're registered, you have to keep that information up to date.
Yes, sir.
Do you understand the concept?
Yes, sir.
If you plead guilty, there will not be a trial. So all the rights I explained to you are given up or waived as a part of the guilty plea. Do you
Yes, sir.
understand that?
Yes, sir.
Do you feel like you're being pressured into this agreement against your will?
No, sir.
Have you been promised or guaranteed a particular outcome?
No, sir.
How's your health today?
great.
No anxiety, huh?
Oh, well, to be frankly honest, sweaty everywhere.
Like everybody else that sits there.
Yeah, that's normal.
It might be, but does that anxiety cause you any difficulties comprehending what we're doing?
No, I understand what we're at. Okay, if you're for the record, I am clearly cognizant. I understand what's going on.
Yeah, I mean, I heard the deep sigh.
Yeah.
It's not unfamiliar
Sure.
for people to be nervous. I'm trying to sort out whether you're pressured, whether you're healthy enough to do all this.
I follow you.
That's why I'm not trying to talk down to you.
Yes, sir.
Okay, so do you take any medications?
No, sir.
Are there medications you should take but you're not receiving?
No, sir.
Any emotional, psychiatric, or concentration problems that are affecting your ability to understand?
No, sir.
How'd you sleep last night?
I actually slept well.
Okay. What about education level? How far did you go through
12th grade.
school? High school grad or just 12th grade?
12th grade, I homeschooled, so I didn't get to
Okay,
get a GED.
all right. So have I used any words or phrases you did not understand?
Did you say that you asked?
Did I use any phrases or words you didn't
No,
understand?
sir.
Okay. The plea form's probably 3 pages plus another attachment, a lot of words. Did you have a chance to read them all?
I probably just skimmed over them.
Did Mr. Pendle go through it with you?
Yes, he did.
With your skimming, your reading comprehension, with his explanation, did you understand those forms when you signed them?
Yes, sir.
You have any questions about them?
No, sir.
You want more time to go over them?
No, sir.
Essentially, they're the same thing that I'm doing now,
Right.
which would be like now the 3rd or 4th time you've heard all this. We're trying to educate.
I understand.
Okay.
Fair enough. Thanks.
Are you a citizen of the United States?
Yes, sir.
Any other pending criminal charges?
No, sir.
Probation or parole anywhere?
No, sir.
Other charges that are expected but not yet filed?
No, sir.
Any alcohol consumption in the last week?
No.
Street drug usage in the last week?
No, sir.
Anything right now affecting your comprehension?
No, sir.
Did I go through this too quickly for you?
No, sir. I understood it.
Did you need more time right now to talk to Mr. Pendle about anything?
Any questions? Clear.
Okay, he knows what's going on.
I know he does.
The test always is whether you do.
I do. I understand it. We
Okay.
went over it several times.
Do you, let me ask it this way. Did he answer all your questions when you
Yes, sir.
gave them to him? If you wanted advice, did he provide it to you?
Yes, sir.
Are you satisfied with the time, advice, the work he's put into this case for you?
Yes, sir. You did a great job.
Did I overlook anything, Mr. Pendle?
I don't believe so, Your Honor.
Mr. Ormsby, overlook anything?
I don't think so either, Your Honor.
Mr. Loftis, do you have any questions right now?
No, sir.
I'm going to make legal conclusions. If you disagree, it's okay. It just means you don't understand something, and I'll go back and
Yes, sir.
clear it up with you. So the first conclusion would be that you understand the charge set forth in the Bill of Information. Didn't ask you this. The conduct date's February to April this year. I don't
Okay.
get the facts, but you need to know them. So do you know what this information's all about?
Yes, sir.
Okay. A guilty plea is a person's conclusion, first, that they understand the law, and second, the facts, which means they know and agree they violated the law. So do you understand the meaning of a guilty plea?
Yes, sir.
Should have said that like 5 minutes ago.
Sorry.
With that being said, now I conclude that you understand the charge, the facts, and the meaning of a guilty plea, right?
Yes, sir. I see why I asked all the others.
Does it make sense?
Yes.
Okay. Now, I went through penalties and consequences. Mr. Pendle should too. But do you understand all the possible penalties for this offense?
Yes, sir.
You've heard the rights that apply that you could use if you wanted a trial.
Yes, sir.
You understand them, right?
I do understand.
You're not being forced into a guilty plea, are you?
No, sir.
My last conclusion would be the most important, that you're knowingly, intelligently, voluntarily waiving trial rights and entering a guilty plea in the same manner.
Yes,
Do you
sir.
agree?
I do agree.
Now, the Bill of Information charges sexual battery. The conduct is February through April of this year in Dark County. It's a third-degree felony. How do you plead to that offense?
I'm guilty.
Any facts for the record, Mr. Ormsby?
No additional facts, Your Honor.
Okay. Discussion about the facts, Mr. Pendle?
Nothing on the facts, Your Honor.
Mr. Loftis, based upon the information which contains allegations, based upon your guilty plea, which is your admission that there's facts sufficient to support the information, all that together is enough reason for me to accept the guilty plea, find that you're guilty of sexual battery, a third-degree felony. Now the case gets referred to the probation department for a pre-sentence report. That's probably been explained to you, right?
Yes, sir.
Mr. Taylor's sitting over there against the wall with a really short haircut. Okay, he's not likely to be the person that does the report, but he's going to get you to the next person who does.
Okay,
Likely Mr. Albright. Whoever the next officer is that takes your case is going to need to have you sit for an interview. Before that, you fill out a questionnaire. They may want to see documents. Often we try to see if there's a diploma or if there's employment, what the status is, verified paycheck, whatever. People say a lot of words, we look for the paper behind it.
true.
I get a 6 to 8 or 9 page report about the facts. So the next time you're in court, I'll know what this case is all about. At that point, I'm supposed to.
Okay,
So between now and then, the pre-sentence report process goes on. Is there a discussion then, Mr. Ormsby, about bail?
We didn't have any discussion that I'm aware of, but he's retained counsel, had discussions with my office, so I don't have any reason to recommend anything other than in personal recognizance bond, Your Honor.
Thank you very much. Mr. Pendle?
Your Honor, as Mr. Ormsby indicated, Mr. Loftis reached out to my office and retained counsel. He's here voluntarily today. We don't believe he's a flight risk. In fact, he's a family man and very involved in the community. We would ask for a personal recognizance bond.
Mr. Loftis, bond is about you coming back,
I understand.
participating in your defense, now participating in the pre-sentence investigation process. I don't have any reason to think you won't come back. You showed up today voluntarily. Nobody had to drag you in with handcuffs on, right?
Right?
So the presumption is you'll be back.
Yes, sir.
So we always start with that's the best thing to do. So personal recognizance is your personal promise, your guarantee, your word that you'll come back. If you don't, you can get arrested without notice. Another charge can get filed, which adds up to 18 more months. We have what we call pretrial supervision. Since you haven't been sentenced yet, pretrial supervision isn't going to be very long or maybe difficult, but if you fall off the rails, then all of a sudden the house of cards kind of sinks on top of you.
I understand.
So personal recognizance, a promise, no cash, no real estate, no other people to guarantee you. There's conditions. See the probation department as ordered. Stay in contact with your lawyer every 10 days. If Mr. Pendle needs you and you don't show up, he's supposed to call me, which means I can make you show up the hard way.
Sure, I
It's
understand.
awkward for him, right?
I get that.
No alcohol, no illegal drugs, random urinalysis. If you're referred for substance abuse or mental health issues, then you have to follow those referrals and be evaluated. You have to follow treatment recommendations.
Sure.
I'm not going to order a sex offender risk profile. That might come from the probation department or your lawyer, depending on how this is going and what they think's best. If you had a broken knee, you'd want to go to a doctor to get your knee worked on, right? If you have a broken head, you do the same thing.
Sure.
Sex offender risk reduction's the same type of evaluation. I'm not ordering it, but it might be ordered by somebody else,
Gotcha.
probation or your
Makes
lawyer.
sense.
Don't violate federal, state, local laws or ordinances. Those are all relatively standard conditions. But I got to break them down and explain it to you, so hopefully that makes sense.
Yes, sir.
October 24. Let's make it 10 a.m. Back it up a little bit from your regular docket. Mr. Pendle? Or did I? Are you at 10 that day, or?
Yes, Your Honor.
So I should back it up to 11. Yeah, make it 11 then. So October 24 at 11. Okay, cross the hall with these papers and this paper. So you sign the bond form, and then you need to see the probation department. When somebody's charged, they have to report that charge to the sheriff's department. So I'm going to give you a booking notification form. When you go to the sheriff's office, go after hours. So what's the, he knows better than I do. We're trying not to have you go at supper time, so you sit there for 2 hours. We're trying to not have you go there when there's visitation, because you sit there for 2 hours. So we try to have you get booked so you're in and out, and the jail staff doesn't have 6 things going on at once. Do you know, Mr. Bailiff, what the schedule is for booking, like tonight?
To go out and work?
Yeah.
They have 6:30 to midnight.
So you take this paper sometime this evening out the jail. When you walk in, if you hand it to them, they'll know what's going on. They're going to take you back to a room, fingerprint, photograph, swab your mouth. And it doesn't matter what the felony is, that's the way everybody goes. So this goes with you. So to the clerk's office, sign the bond, the probation department, get this out there tonight. It gets routed back to us. And then we'll see you back here on the 24th at 11 a.m.
Yes, sir.
Overlook anything, Mr. Pendle?
I don't believe so, Your Honor.
Mr. Ormsby?
No, Your Honor.
Okay, you have any questions right now, Mr. Loftis?
No, sir? Except
All
for
right.
where's that location at, just across?
Yeah.
I'll walk you over there.
Thank you.